just so everybody knows that we're doing that. We're doing it as this is a webinar, so you're not going to be able to speak, but we do welcome your participation and we encourage you to ask questions in the chat feature. And I and our illustrious intern, Ellie, will try to keep up with those. I'll probably try to address those maybe a couple times throughout the program. We will be we are recording this, and so it'll be available later. And we also will share additional information with some links and other things. And then, of course, you can find me if I can help you. So I'm going to go ahead and share my screen with the PowerPoint and get going here. So, okay, sorry. So, all right, so we're here to talk about Freedom of Information Acts, both the federal and state versions, although my experience is much more with the state version, so that's going to be the bulk of what I'm going to talk about. And I'll just jump right in and say that there are quite a few things that are in common between the two programs. And first of all, it's just with the basic principles on which they're founded. The US FOIA was passed in, I think, 1966. And I'm not sure the origin or the date of the Virginia Act, but they followed many years of people being frustrated with not being able to get basic information, especially from the federal government. Previous to that, there was a standard that essentially said agencies can withhold information if it's in the public interest for them to do so. And as you can guess, they use that judgment very, very forcefully. It's your government, they're your records. You have a right to be able to see them in most cases. And that's the principle on which these two laws rest. The default position should be that materials are available to you, not the other way around. You shouldn't always have to be justifying why you need things. In fact, in general, you shouldn't have to justify why you need the information. They should be able to tell you if there's a reason you can't get it and what that is. There are, of course, sometimes when it makes sense that the government should withhold information, you know, security reasons, personal information for employees or constituents, things like that. But they're supposed to be limited. They're supposed to be really well explained, and they're supposed to tell you what those reasons are. So, hold on, I think I skipped one here. Yeah, so again, there are a lot of things in common. In both cases, the agencies involved have a deadline for how quickly they're supposed to respond to you. You'll hear that Virginia's, in my experience, is a lot better. And so that's one place I can praise Virginia government. There are many of which I criticize them, but that's a good one. The reasons why, again, they can withhold things are defined pretty closely. If you look in the Virginia law, I think probably about 30 of the 50 some pages are spelling out very specific reasons that they can withhold information. So they go into great detail. The good thing is that most of those are never going to apply to most people. Different agencies do have slightly different procedures. Now, the state folks in Virginia, I have not found huge differences from one agency to the next. I see a little more variation amongst federal agencies. So sometimes it will be important if you're working with a particular agency, you'll have to go and learn some of their unique wrinkles on how they do things. This is a bit of commentary here, and that is that sometimes agencies withhold information or tell you that you can't get it, or they use excuses for a delay, and they really shouldn't. And sometimes I think that is just because they think you won't challenge them. And so I think it's always important to let them know that you're keeping up with the information, with the rules, and you're going to push them. The good thing is that, you know, there are lots of good resources out there. And as I said before, I'm going to try to give you some of the best links and things in a follow-up because there is a lot of help. And don't be deterred. If you want to get information from your government, whatever level it is, you have the right to do it. You don't have to be a lawyer. You don't have to have a lot of specialization. If you run into problems, a lot of times you can get help from the agency folks themselves. So don't be deterred by thinking that it's just too hard. I'm talking a lot tonight about how requests are made and what some of the details are, but I wanted to just talk about why you make FOIA requests. Now, I don't know how many of the folks on here have done requests in the past, but obviously the biggest reason is that there's specific kinds of information that you would like to get from the government. A lot of the processes that we deal with, whether they be pollution, permitting stuff or regulatory changes, they put information out there in public notices and in other forms on their website. But a lot of times they don't include the kind of details and the kind of specific information that you can use to better understand what they're up to. You might really want to know what the kind of internal discussions are in the agency. And again, in Virginia FOIA, they can't shield a lot of that stuff. We have found some fairly interesting things back and forth between different agency employees that they probably shouldn't have had on the record, but they did, and it's been very useful to us, but they're not going to advertise that kind of stuff. The other reason you might want to make FOIA request or ask for government information is that you can use those requests as a point to bring things out in the public. I'll give you one example. We know at one point, or knew at one point, that when the state of Virginia was looking at the Atlantic Coast Pipeline, when they were doing the regulatory process, that the CEO of Dominion Power went and had a private meeting with the governor. We and a lot of other people suspected that their discussion might have dealt with that issue. We couldn't prove it. We made a FOIA request of the governor's office and of the agencies involved. Now, we knew that because of some exemptions I'm going to tell you about later, that we might not get that information. But what it allowed us to do is to raise this issue. Should the governor be meeting with a person like this in a private meeting? And if he is, should it be something that we can get information about? And so that was an important kind of statement to make, an important thing to bring out in the public, even if we never expected to, or even if we never could get those records. We wanted to bring it out. So there's a lot of words here. I'm not expecting you to go through them all, and I usually don't try not to put this much verbiage into my slides, but I think it's important to know some of the specific wording. When you are trying to get an agency to apply a law or a regulation, it's always good to go back and be able to kind of remind them of what this whole thing is about, why they're supposed to do what they're doing. You know, under the Virginia law, it makes very clear that you're supposed to have ready access to those records and free entry to public meetings. Now, I'm not talking much about meetings here tonight, but that's a whole other side of the Virginia FOIA law, and it's just as important. One thing about Virginia law, the FOIA, is that it only applies to citizens of the Commonwealth or representatives of certain kind of media, publications and broadcasting media that serve Virginia. So that's a limitation that probably it could be a problem. Now, if you're representing an organization that is based in Virginia, and I think you're covered there. And finally, an agency or a representative of an agency may well not even be worried about that. They may not exclude you because you're not from Virginia, but that's a wrinkle that it's good to know that you might face. Again, this is just a really strong statement that our legislators made when they came up with this law, that, you know, these things aren't supposed to be done in secret. They're supposed to be working for you, and you're supposed to be able to track what they're doing and why they're doing it. So just a little philosophy behind the whole thing. And again, this is way too many words, but one of the basic things is you can get access to public records, so you have to know what those are. It may seem obvious, but you may face somebody saying, well, that's not really a public record. Now, I will tell you that there have been times in the past when I've had agency people say, well, yeah, you can get, you know, the fact sheet for this permit, you can get some of these official documents, but you can't get these meeting notes. Well, they're wrong. You can get those meeting notes. You can look at this list of things that are supposed to be available as public records, and it's pretty extensive. It really is kind of all-encompassing of the kinds of things that might be available. Now, since we have more electronic media, since really almost all the information these days is in that form, I think they've come up or kept up pretty well in acknowledging that and making that part of this thing. But, sometimes when you're going to make a request, you might pull out some of these specific kinds of things and say, hey, I don't just want the electronic documents that are already there. I want everything. I want handwritten notes from the meetings. And I'll just get this question real quick because I just saw it pop up. Are text via personal cell phone subject to FOIA? That's a good question. That if they're doing public business, then it should be available through FOIA. And I think that, whoops, I'm jumping around here. Sorry about that. Again, as this says, electronic recordings, electronic or digital files, all those kinds of things. I mean, texts should be available. Copies from calendars where people have appointment notations should be available. And again, sometimes when I make a request, I don't get into a lot of those specifics because I don't believe that all those things are going to come into play. But I have asked very specifically sometimes for handwritten notes about phone calls or about specific meetings because I had reason to think that there was going to be something interesting there. And again, the other part that's underlined here, things that are prepared or owned by or in the possession of a public body or its officers. Again, that's pretty all-encompassing. They didn't have to create the document. It just has to be something that they're a possessor of, a custodian of, and that's a term that you'll hear. Okay, so there's public records, and then the public body is the entity that holds that record. And they're the only ones that you can ask for this information. Now, again, that includes a lot of different kinds of entities. One thing that we encountered here recently, or that we were reminded of, is that I, on behalf of Wild Virginia, am a member of a regulatory advisory panel. That's something where we volunteered, and DEQ chose us and a bunch of other people to be part of this discussion. We don't have any decision-making power, but we're supposed to be able to give them advice. And so you see here that a public body can include a committee or something like that that can advise the government. So there is, you know, it is a wide range of kinds of things. And I know there's some questions and hands up, and if you're putting your hand up, maybe try to go ahead and put your question or your comment in the chat. And I'm going to go a little bit further and then kind of try to loop back to some of those things in the chat. Now, when you go to make a request, or when you want information from a government agency, sometimes you can bypass all the complications and all the formality by just reaching out to the people who you think have that information. Just several weeks ago, we knew that there was a document that DEQ was going to have, that they probably produced it that day or the day before. And so I just contacted the guy who probably was going to sign it and said, please give me a copy. Now, he could have forced me to go through the formal process, and he could have availed himself of the 5-day deadline or whatever. But a lot of times they won't do that. I mean, if you can get along with them, if you can ask for it informally, obviously that's a better choice. And again, if you go to the right person, if you try to learn who is going to be the kind of the frontline individual, often they'll help you out. One of the things that I've had to bring up with them is that, hey, there's stuff that used to be on your website and you took it down from your website. So, hey, can't you just tell me where it is, or can't you just send it to me? And that's been useful. One thing with the state agencies, this is DEQ and many and all the others really, is that when you make a request, you don't have to say this is a request under the Freedom of Information Act, and they still have to treat it as a FOIA request. So you may call up somebody and say, can I get this information, or send them an email or whatever, and they may say, oh, that has to go through FOIA. So sometimes they will, sometimes they won't. I mean, it's kind of a measure of self-defense for them to go that way, because then, you know, they're not accused of having kind of bypassed the system. Let me see here. I'm sorry, I'm jumping back and forth. Okay, Ellie, maybe it's a good time to stop and see what we got in the chat. Is there anything interesting there?
Let's see. I don't think we have anything new except for continuation of Brittany's question, which I think you've explained.
Okay.
About agencies compelling employees.
And somebody had their hand up. Did they fall?
Yes. If you had your hand up, definitely put it in the chat if you can.
Yeah, we want to make sure we hit whatever you need. I'll plow ahead and we'll give you other opportunities. So don't hesitate to ask. Okay. So as I said before, whether it's federal or state agencies, they do have the authority and the ability to say there's certain things you can't get. And there's good reason for that in some cases. In the Virginia statute, there are dozens and dozens of examples of reasons why they can withhold information. As I think I said before, a lot of those you're never going to encounter. I mean, there's a lot of things about personal information of employees, like, you know, what their benefits are and what their wages are and all. Now, some of that is open, but, you know, you don't want everybody having the personal, you know, information of every employee in government. You can't expose, you know, some of the stuff as far as criminal justice or security things to the public in general. So again, if you go into the law, you'll see that there's page after page of those. But in my experience, which is, I've done a lot of FOIA work in Virginia, I've only run into two specific exclusions or reasons why the agencies wanted to withhold things from me. One is they said it was covered under attorney-client privilege. If you're not really familiar with that, essentially it is that if I'm an attorney for a party, whether it be a government agency or an individual, I can't go talking about the advice I've given that person or that entity without having their okay for it. And very often they're not going to give their okay for that because they don't want what they're talking to their attorney to be revealed. So that's an understandable one, of course. There's another one called working papers, and it's a specific section within the law, and I'm going to get to that in a minute. But in both of these cases, and in a lot of the other cases where they claim the right to withhold information, what the law says is the agency has that ability, but they're not required to. So while they may say, we're going to withhold this and we have the right to withhold it because of section 3G6 in the law, very often they have the flexibility, they have the judgment, they can make the judgment to give it to you anyway. Now that's been kind of useful for us in a number of cases. And I'll move to the next thing that'll help you understand. We've made cases in the past or made requests of the governor's office and the Secretary of Natural Resources because they were heavily involved in specific decisions that we cared about within the DEQ and with other agencies. Now we know that there is this thing called the working papers exclusion in the law. Covers the office of the governor, lieutenant governor, attorney general, lots of other parties. So under that exclusion, if the governor's office says this is working papers, we don't have to give it to you, then generally they have the authority to do that. What we did is we said we want it anyway. We're asking for it. We're acknowledging right up front that you're not required to give it to us, but you should want to give it to us. And this gets at that kind of tactic that I was talking about before, that making requests of your government and making them public, making some noise about them can be a tool. What we knew is that if we asked the governor's office, you know, give us this information, even if you don't have to, then they had two choices. One was to go ahead and give it to us, even though they probably didn't really want to. The other was to turn it down and then have us tell everybody, hey, they're keeping secrets. So they're kind of in a nowhere-in situation there, which is where I like to have them. If you're in Virginia, you should know that the secretariats, like the Secretary of Natural Resources and any other, you know, Secretary of Labor or whatever, they're all technically part of the office of the governor. So any exclusion that applies to that office also applies to them. And that's tripped people up, I know, more than once because they didn't realize that. Okay. How about I pause now and try the chat because I see that there's some more stuff there.
Sure. So actually, Brittany was going back to her follow-up question. I don't think we completely answered it. But she
Okay.
asked if agencies can compel their employees to make their personal text available for review, or if they just will trust that employees will turn those over related to public business.
Um, you, you're getting into hard questions that probably may or may not have been tested legally in my knowledge. Again, I would say that if they're using that phone for text or calls or anything and they're doing official business, then I would think that the agency could tell them, yes, you must make them available. Question is the agency even going to know? And they may have a legal right to resist. I just don't know. So I'm sorry. That's one that would probably be fought over if it came up. Anything else?
Then another question from Brittany that's separate is asking if she can request communications to or from a member of the General Assembly surrounding a particular bill.
You absolutely can. Now, let's go back. There is a working papers allowance or exclusion that covers members of the General Assembly. But most things that deal with a bill that's going on right now, they're going to give it to you anyway. In fact, you're almost never, I think, in those cases, probably going to have to go through a formal process. You'll just talk to their office and they should give it to you. Now, if they do, again, if they say you have to make a formal FOIA request, then you can do that. And again, you'll face this question: are they required to, or just should they? And that's where my previous idea came in, that even if you can withhold it, why would you? You're doing the people's business. You're working on legislation that's going to affect us all. Obviously, you should make it public. So they may try to hide some stuff, but I think that's more likely to hurt them than to help them. Anything else? Right.
And the last question is from Grace asking if you have any tips about getting fees waived, which I think you're going to cover.
Yeah, I'm gonna talk a little bit about fees in a little bit.
Okay.
Okay. All right. So a lot of times when you're seeking information from an agency or from a government entity, you're trying to get it quick. There's a decision that's going to be made a week, 2 weeks from now, and you'd really like to have this information so you can use it. The good thing about Virginia that is better than the federal government and a lot of other states is that their initial response has to be made to you within 5 working days. And again, of course, that doesn't count weekends and holidays, but that's a pretty quick turnaround. And they must make one of these 4 responses to your initial request. They can tell you, no, we're withholding either all or part of what you asked for under one of these exclusions. We don't have to give it to you, and we're choosing not to. They can say those records don't exist, we couldn't find anything, or they can say it's not practically possible to give it to you within this 5-day period. Of course, the other thing is they can just go ahead and send it to you within that 5-day period, which is not one of these listed. That's obviously the optimal. And many times I've gotten that, that kind of service. I have found that state agencies in Virginia, especially the Department of Environmental Quality, in recent years especially, have been very easy to work with. So I don't, unlike some circumstances, I don't go in expecting them to put up a fight because in general they've been pretty good. But again, you might get one of these responses. The one that I have had some fights over is the not practically possible. When they say, we just can't do it within 5 working days, we have to take this extension, which gives them 7 more working days. Often that's a real inconvenience. Now, several years ago, in one case, they claimed that it was not practically possible. And we fought back, and I'll talk a little bit about that. But they really need to explain any of these decisions. If they say it's not possible, then they should tell you something about why that is. Now, there's a range of reasons they can claim, one of which is we've just got a ton of requests this week or this period, and so you're in line behind other people. Now, that's not a very satisfying answer, but it's a realistic one. We got a response once that was, well, that employee's not here and we can't get into his computer. We didn't think that was a very good answer, and we didn't accept it. When they say that they're going to withhold all or part of the records that you asked for, they need to spell that out. They need to say, this is the specific exclusion that we're claiming. For example, it's governor's working papers. They need to give you an idea of what that's all about. You know, are there 500 pages that we're withholding, or are there 2 email messages? They need to give you some of those specifics so you know what it's about. And then if you have a reason that you think it might be challengeable, you can do it. So to kind of avoid some of the pitfalls, you do need to think about how to make the best request. And that's probably what I get the most kinds of questions about from people is, you know, do you have an example of a FOIA request you've made? Will you look at mine and give me tips? So I'm going to try to give you some. There's so many things that could come up. But of course, the first one is just try to make your request as precise and specific as you can. If I ask the DEQ, give me all the stuff that went into your decision on Mountain Valley Pipeline, I'm going to get, you know, first of all, they're going to say we need huge amount of time, and they're going to try to give me thousands and thousands and thousands of documents, which is not going to be what I need. It's not going to be that useful. It will bury me in information. So you got to think about, you know, how do I explain, how do I describe the information that I really need in a really precise way, and what time period do I need? You know, if I just simply ask about, you know, stuff about this particular discharge or this particular permit, and I don't specify a period, they can assume that I want everything they have back to 19 whatever, 70 something. And clearly that's probably not what I need. And a lot of times they will come to you and say, hey, this does just go way back. You don't want everything, do you? But it's best for you to just think of that up front. Now, sometimes, you know, if I know that they were contemplating a decision, say one that was made last December, that was a pretty important one, some of you know about. If there were conversations, if there were memos flying back and forth, I may ask for the 6 months before that or the year before that, which will give me a good time frame, and I can probably get what I need. I may not want everything that anybody in the agency has written or has in their documents about an issue. I may just ask for what a specific person has in their files or what they have written. One of the things you'll get very often is if you ask over a certain subject area, is what they practically do, and again, it makes some sense, is they'll go and they'll say, okay, this is the population of people. Maybe there's 15 people in the agency who we know works on this issue. So they'll ask all those folks to forward to them all their emails and all the documents that are responsive. So you may get the same email strings over and over from those different people. So it's kind of a pain, but that's the best way probably that they can make sure that they're getting you everything that exists. But again, just always think as narrow as you can go to get you to where to what you can really use. In doing that, sometimes, I might want to cover a whole bunch of different issues, but it can be useful for me to break it up. I may put it in several different bullet points in one request, or I may just send several separate letters with each thing there. Part of the reason I do that is that sometimes what I'm asking for, I suspect they don't have. For example, I asked at one point, give me all of the analyses you have that supports the contention that this particular permit won't violate water quality requirements. I didn't believe that they had done any real analysis. So I very specifically worded what I was looking for and said, if you do not have this information, please state that in your response. And they had to respond by saying the agency has no records that are responsive to your request. And then, of course, we produced a whole big report with the title, "The agency has no records," because we were making the point that they just didn't do their job. And by phrasing it the right way, framing the request the right way, they had to tell us that. Again, a lot of times you are in a hurry, or at least usually I have been, because you're trying to meet some deadline, you're trying to get official comments submitted. And so you need to think about, again, they do have some limitations on how quickly they can do things sometimes. Again, if I'm asking for a whole slew of different kinds of information, I may tell them, if you can't get it all to me within 5 working days, or even within the additional 7-day period, I want this first. Please send me this, even if you don't have everything else assembled. And again, I've had pretty good luck with them doing that. They've been pretty easy to work with, or sometimes they'll offer that to me and say, some of this stuff is really complicated. We have to, contact more and more people to figure out whether they have this stuff, but we already have this amount of information, and we'll just go ahead and send it to you. So be thinking about the practical aspects of this. If they come back to you and say, hey, we absolutely need that extension, we can't get it all to you within 5 working days, there's nothing wrong with saying, hey, why not? Can I cut out part of this? Would you then be able to meet the deadline? And again, I've had pretty good dialogues. It's worth pursuing that. It's worth asking. So fees, there was a question about that before. And this is a place where the feds and the state of Virginia are different. The law, of course, says that they can make reasonable charges. That's supposed to cover their efforts, their time in looking for the information, in compiling it, and in getting it to you, whether they do that electronically or whatever. Now, generally, well, it used to be that a big part of the charge might be copying charges, where they would give you all of it in paper and they would charge you so much per copy. That probably, as you can expect, isn't usually a big part of this whole thing. You may need paper copies of some things. I know in the past there have been times when people have asked for, huge plan sheets, big things, and they had to figure out how to do that, and they were able to charge for that. But as a practical matter, when it comes to things nowadays, it's usually electronic, and there's no specific charge for sending something through email or through a Dropbox or whatever. So what you'll see normally, if there's a charge, is we think it's going to take 8 hours to produce, and we're charging an hourly rate of X, $15 an hour, whatever. Now, sometimes I've questioned that hourly rate. When I made request of the governor's office a number of years ago, they wanted to charge me something like $30 an hour. And, basically I made the point that, that's what one of your good attorneys might make, or maybe your starting attorney. Are they really the ones who compile all this information and who do your FOIA work? I don't think so. But they'll come up with a fee. It's always worth looking at it and asking, is this reasonable? Making your case. There is no explicit allowance in Virginia law for nonprofits or anybody else in particular to get a break on the fee. Now, I used to, as a matter of course, every request I made, I just said, we're a nonprofit. We're going to use this stuff for the public good. We're going to distribute it to our friends and our members and allies. And sometimes they did not charge me, but I had no legal right to demand that they not charge me. And sometimes they've just come back and said, no, we don't have to give you that break. Again, I'll say that a lot of times they will give me a break. They'll say, okay, the first 50 pages we'll give you for free. And since it's taken a while, we'll give you more of an allowance. So, but I've had some pretty big charges. I've had charges in the $500, $600, $700 range in the past. They are allowed to ask you for a deposit in certain cases when it's a big fee, and they can stop production of the information until they get it. You think that answered the question that Grace had?
I think so, but Grace, if you have anything else, you're welcome to type in the chat.
There you go. So again, sometimes you'll get that answer is that we're not going to give you the information. Sometimes they don't answer at all. That is rare, but it happened once. Or at least they didn't give you one of the answers that the law requires. Sometimes they try to charge you a fee that you don't think is appropriate. You do have a right to challenge their decisions on any of those items. What we did years ago is, in a couple of instances, we said, we don't like your response or your lack of response, and we're going to sue you. And that made them know that we were serious. The first case, we had made a request of DEQ Director Paler and the Secretary of Natural Resources. And after their 5 work days or 6 work days or 7 work days had elapsed, I wrote them a note and said, where's your response? And they said, we're working on it. So I said, that's not a legal response. That's not adequate. So we prepared the papers to go and take them to state court. We shared them with the agency because if we did that, the court would do an expedited review. And lo and behold, we got the information within hours, probably less than 3 hours. They went ahead and got us the information while they'd been dragging their feet before. There was another case, I think I mentioned it earlier, where they just said, we can't give it to you within the 5 work days. And we said, you're not giving us a reason why it's not practicable to do that. You got to do it. And so we challenged them, and lo and behold, again, they came along and gave us the information. So if you've gone through all that and you've finally gotten information from the agency, you can get it in different forms. Like I say, a lot of times it's just electronic. They have this system called VitaShare, which is kind of their version of a Dropbox, that they'll make it available to you for a certain number of days and you can go grab it. Now you can ask or a flash drive or a disk. You can even ask to go to their office and sit down and look at their files, whether on paper or electronically. They don't want you to do that. And frankly, right now, I don't want to do that. And it's probably not the most efficient thing, but you do have the latitude to ask for it the way you want it. The last thing I'll say about that is that even if you're really careful about how you ask for things and how you limit the scope of the information you want, you still might get a ton of stuff. I got a response last summer, I guess it was, or spring. It included something like 100 gigabytes of information. Huge, and hundreds of files, thousands of files. You need to think about how you're going to actually get through all this information once you get it. Sometimes you have great ambitions about what you're going to be able to get, but you need to think ahead about how am I going to use it? How am I going to review it all? And what am I going to do with it? So I'm going to turn it over to Ellie, but first I wanted to see if there's any other newer questions or whatever.
Yeah, one question that relates to kind of what you were talking about is, I think I'm understanding this right. What do you do if after submitting a request and receiving the information from an agency, you feel like they didn't provide you everything they should have?
Well, again, you're going to have to figure out how to make your case. You can, obviously you'd follow up directly with them. If you knew, let's just take an example. If you knew that X person within the agency was working on this issue and you never got the first email from them, they'd been working on it for a year and there wasn't even the first email from them, you'd have a pretty good reason to suspect that something got left out. And so the first thing you would do is just go straight to the agency and say, hey, I don't think you gave me what you're supposed to, and just see how they respond. Again, your backstop is go to court and challenge it, but you're going to have a plausible, explanation as to why you think they haven't done what they're supposed to. The hard part of all that, of course, is that, they're kind of behind this wall, and you can't be sure whether, they have withheld things necessarily. I will tell you that one way you can find things out is that we have seen where we made requests of more than one agency at one time on common information. One agency would give it to us and the other would not, which told us that this agency is not playing fair. They're not actually giving us everything that they have. There have been times when things, we knew that other members of the public or other people had gotten information, and then when we made a request, it didn't show up. That gives you the basis to go to them and say, clearly you excluded this, you didn't have the right to, so we want you to go back and look again. Is there anything else you left out? Because now we have reason to suspect you. But it's tough. Again, I mean, if you're going to go to a judge and say they didn't give us what they were supposed to, you got to have some reasoning to convince that judge that you know what you're talking about. Not totally easy. What else you got? Anything?
Another follow-up question from Brittany about the General Assembly members. She said that you said their staff should turn over info from FOIA requests, but the staff from her delegate didn't respond to any of her email requests for a meeting, about a dozen emails during the 2021 session. And so she wants to know, like, who else could she ask, because they're probably not going to respond to a FOIA request. Okay.
So first of all, let me be clear. Sending an email and saying, can we have a meeting, is not a FOIA request. The other thing that's not a FOIA request is asking them to prepare a document. You know, I can ask my delegate or a member of an agency or an official, explain to me why you have this position, or explain to me why you didn't do X, Y, or Z. That's not a FOIA request because that's asking them to do something. It's not just them passing information to you. So I think you need to be careful about, is it a public record? You go back, is it an existing record that they have in their possession and that they should give you? As far as them just not responding at all, the fact is that the only people that legislators work for is the people who elect them. Again, taking things public can be worthwhile. Talk to a reporter, talk to, other people in your district or who may have the same interest, and make some noise. That's the thing that politicians may respond to, is some public demand. So that's probably the best I can give you for that. Anything else right now?
I think that's all for now.
Okay, well, I'm going to turn it over to you, Ellie. I want to introduce Ellie. She's been our great intern last semester and starting in this semester. And I asked her earlier to spend some time just figuring out what the FOIA, or the federal FOIA, was all about. And so I just asked her to give you a little bit of what she found and kind of her impressions of the whole thing. So take it away.
Yeah, so I didn't know at all really what FOIA was. Maybe I knew of it, but didn't understand how citizens could get information from state and federal agencies prior to this. And definitely, I would say it's looks intimidating and complex to navigate from the outside, and it can be, but the actual process of requesting is pretty straightforward. And so this website is super helpful and kind of very user-friendly as far as providing comprehensive information geared towards basically teaching the public about FOIA and the request process. And so I think one of the most helpful pages is probably the frequently asked questions pages, which Dave can maybe click on there. It's under Learn About FOIA. Sorry, I don't have my screen shared.
This is just a screenshot. This is not the.
Oh, never mind. I thought we were on the website. That was my bad. Anyways, no, you're totally fine. So the frequently asked questions page has just a ton of general info about the basics of FOIA and info about how to make the request, who's handling it, fees and fee waivers, exemptions, and timelines of when you should get a response.
Sorry.
I think we kind of covered. Oh, sorry. I think we kind of covered the timelines, but it definitely, I think it's different for federal. As for example, the EPA had a general timeline of much longer than 5 days when they would get back to you, which is unfortunate. But I guess just good to know so you can plan the timing of your request. And then there's also some info for before you request. The site allows you to research information that's already publicly available. So agencies have to publish what they've already had to submit FOIA requests for. And so that saves you a lot of hassle just having it right there instead of having to wait for a response. And then the create a request tab is basically super useful. You just search the agency. So you could search US Fish and Wildlife, EPA, and it'll take you to that site's agency specific process, who you can contact, their general timeline for response, and all that good stuff.
That's great. And I'm glad you mentioned the thing about searching what people have already requested, what they've already made available. That kind of gets at the question I was addressing before, is that what if you think they haven't given you everything? Now, if I ask for something and then I realize that they gave it to somebody else and they didn't give it to me, then that's a pretty good basis for me to go to them and say, hey, you're not divulging everything here. And I think that website and a lot of the specific agency websites have really good stuff. I was surprised because I think they've gotten a lot better at how they deal with the public and allowing you to make the request. Now, that doesn't mean that they're necessarily all that much better at giving you the information. There's still a lot of hurdles there. I'll point out that unlike Virginia, you can specifically ask for a fee exemption. under a public interest provision. And being a nonprofit or being anybody who says, this is not for my own personal interest or my commercial interest, I want this information, I'm going to give it to the public. This is valuable to the people and I'm helping disseminate it. You can very often get that fee exemption from the feds. They do, as an initial matter, usually have 20 days to give you an initial response. And there may be, I'm sure there are examples where it's even worse than that. If they don't respond in the timely way, or if you think there are other problems, you can usually make what's called an administrative appeal within the agency, where they have some kind of independent body that looks at it and acts kind of like a judge to decide before you end up going to court. And unlike Virginia, which limits it to citizens of Virginia and some other entities, anybody in the US can make one of these. Again, my experience with the feds is a lot more limited than with the state, but I had dealt with these agencies. Forest Service, I've found in my experience to be relatively good. Corps of Engineers, relatively bad. Fish and Wildlife, somewhere in the middle. As I say, just the time periods, and Ellie mentioned this, you just cannot count on getting the kind of quick response and getting the things provided to you as quickly as we can here in Virginia. And that's something to be grateful for. I think that there's a bigger difference from one agency to the next within the federal government than there is within Virginia state government. Virginia agencies, they have some quirks, some wrinkles that are a little different, but I haven't found them to be all that major. Now, we did have an occasion where we asked the Fish and Wildlife Service for some information, and they came back and said, I think they may have given us 2 pages of information and said, we're withholding the other 500 pages or something like that. And they gave us a reason, which, yeah, it's one of those reasons that the law allows, but they didn't give us any reason why it made any sense. And it just didn't. And they are required to give you some explanation. So we took them to court, or our attorneys, Appalachian Mountain Advocates, helped us take them to federal district court. And again, lo and behold, they settled. They got us the documents we wanted, and our attorney fees got paid because they essentially were admitting that they didn't follow the rules. So it's always good for them to know that you're willing to go the distance to get what you want. Now we're at the hour, but are there any other questions that I can try to get through pretty quick here?
Just got one. If you plan to challenge after any administration appeal for federal FOIA, is there a specific court you need to file in for both state and federal?
State is easier. You can usually, since most agencies are in Richmond, you can go to Richmond District Court. It's possible that you can go to other either district or circuit courts in Virginia, but that's something that's fairly easy to figure out. As far as the federal, it's going to be a federal district court. We went to the federal district court for Western Virginia because that's where we're based. And that was allowed. Again, if you go to the length of deciding you're going to bring a case, that's something an attorney can easily tell you. But that's not so complicated. Anything else?
I don't see anything right now.
Okay. Well, we did record this, at least presuming that I did it correctly. And so we'll make that available. We'll give you links. I also want to, there's a number of good resources in Virginia and otherwise there's something called the FOIA Council in Virginia, which is kind of a quasi-official body, and they have a lot of great information. So we want to get you that stuff. I just want to thank you for being here. I hope this was worthwhile. You can find me if you have follow-up questions. And I do get questions about this fairly often, and I try to help folks just to understand that there's a lot going on, but I love to help people with it. I want people to get their government information when they need it. And so I appreciate you being here. Anything else that we need to wrap up with?
I don't think so. I think there was a question if we'll email the link, which we'll email this link here. Yeah.
Yep, absolutely. Okay. Well, I guess that is about it. I'm going to stop sharing my screen, and everybody have a good evening. And let me see.